SJC-11372, Commonwealth versus Gentile.
Thank you, Fran.
All right, counsel, let's proceed.
Good morning. My name is Catherine Neves. I'm here today on behalf of the defendant appellant Conan Gentile. Instead of an objectively reasonable belief that Mr. Gentile was present at apartment D, 429 Mechanic Street, Leominster, at 9:40 a.m. on June 24, 2010, what the trooper in this case had were layers of his own subjective belief that Mr. Gentile was there.
Well, Mr. Gentile had declared that was where he lived.
That's correct. We're not challenging the first prong of that.
Right. So, but that's not irrelevant to the second prong.
It is not. That's true.
Where he lived there, his license, he was licensed from there, goes to the door asking for him. The person at the door acts very nervous, starts looking behind. No, he's not here. That's not evidence that the trooper can take into account in evaluating whether or not he is there?
I think that's nothing more than she could have been nervous for any number of reasons. I think the question is it a reasonable inference to draw that he was there? There could have been contraband in there. There could have been any number of reasons why you'd be nervous at 9:40 in the morning when there's a trooper at your door and he's standing in your threshold.
Looking for the person who lives in your house.
Looking for a person who has given that address as his residence.
Who he reasonably, you just said, who he reasonably believes lives there.
Does reasonably believe he lives there. But I believe that when you look at all, there are no other.
Well, there's one other piece of evidence, and that's that the trooper hears the noise of human movement back in the apartment. So there's somebody there.
That's correct, and that's correct. And it turns out there was also a fourth person in the apartment as well.
Yeah, but that was after the fact, though, wasn't it? After the sound was heard.
Well, no, she was there the whole time.
I know she was there,
yeah.
but they don't know that particular human being was there.
Well, didn't she actually
Correct.
open the door?
No, there were
The defendant's daughter was the third woman.
Was the third woman there. And I think I would direct the court to United States versus Hill, which is cited in my brief, at which the Fourth Circuit said, noises alone inside the residence doesn't give.
But it's not noises alone. It's a noise and nervous activity and looking back into the apartment right on the heels of the trooper asking if this defendant is there.
Well, that was the only reason the trooper was there, was to ask if Mr. Gentile was there. And she said several times, no, he's not here. She did not give him consent to enter. Detective Wolfersater said this was not a lengthy conversation. He said that they entered within seconds of the door being opened. So essentially, she says, no, he's not here. He says she's nervous. She's very nervous. I think that probably a lot of people might be very nervous. She's looking back into the apartment, and he says, I think he's here, and in they go.
Well, he had a warrant, so
He
didn't have to have her permission to enter the house if he believed that the defendant was there.
Absolutely not. But that is another factor, and it goes to the question of whether there was an objectively reasonable belief that, the trooper had at that moment that Mr. Gentile was present in the apartment. I think the reason for the objective standard here is because it's hard to measure this. This is nothing. The motion judge said, his findings were the trooper has a sense of sincerity and credibility in dealing with people, so he knows when someone's lying.
Oh, okay,
Well-
but you do have all the facts that people have just mentioned. What else would you say needed to be there?
Well, I think that you need an objective belief that he was present. I mean, this was.
But what would it be in this circumstance?
It could be any number. I mean, the cases do turn on facts and circumstances, and in fact,
Surveillance is what.
there's some survey. Usually, officers will look, see. They never saw him there. They never ever. They based it on him saying
But that's, I mean, it is true that a lot of the cases involve that kind of surveillance, but it's not a requisite.
It's not a requisite, but it does give some sort of objectively reasonable basis to say, you know, I kind of know his schedule, no evidence about whether he worked or he didn't work. We know this was a weekday because the trooper testified at the hearing that he was working Monday to Friday shifts during the day. So this was not a weekend where you'd say, well, it's 9:40 in the morning, so on a Sunday morning, so you might expect him to be there. It's 9:40 on a workday. There's no record evidence that he worked or didn't work. You might not expect him to be there. There was no, you know, many times there's a car in the driveway. Or when the person answers the door, they don't say he's not there.
Well, but
They-
sometimes when the person answers the door, they'll say, he's not here, and when you see that bum, tell him to get me the $50 that he owes me, or something like that. That kind of a conversation didn't take place here. There was a conversation that suggested he might be in the apartment.
I don't think there was anything in the conversation that suggested that he would be in the apartment. She said he's not here. She hasn't seen him in 4 or 5 days.
Now, your complaint really is that the police officer said, I can figure out when people are being truthful or not.
Right.
And you don't want to leave it to the police to say, I can tell when people are telling the truth or not.
That's correct. That's exactly right. I think it makes it very hard, especially when there's not something else. You know, just noise in the apartment, that doesn't say anything. But it makes it very difficult. I mean, the police can always say, well, you know, they said they weren't there, and you know, I thought they were lying, so I went in. And, you know, the courts are never going to see when it turns out the person wasn't lying, because there won't be the person there to arrest on the warrant at that time, and there won't be a motion to suppress, and we won't be here. So, I mean, I think there is a very good reason to have that standard in place. I mean, this is the sanctity of a home. Yes, they had the warrant, they had probable cause, it gave them the ability to go in, but they still need an objectively reasonable basis.
Is that objectively reasonable man in the street, or objectively reasonable for an experienced police officer, through the eyes of an experienced police officer?
I think I mean, I think the case law talks about, you know, that objectively reasonable based on the inferences that, you know, a police officer with his training and experience would have. You know, I mean, how do we know if a police officer is really good at telling whether someone's lying or whether he's really bad at it? I mean, there's a reason why this standard relies on some of those X factors, a car in the driveway. Someone said, yeah, he's always there. You'll always find him there in the morning. Something of that nature that gives a little oomph to the notion that she said he wasn't there, but I thought she
So
was
you
lying.
take the position, then once they said he's not here, the police should have just left, said, thank you,
Yes.
good day.
Sit outside and wait for him to come out and go somewhere and arrest him then. You know, that's not hard to do. They were just driving around, you know, arresting, and these were 2 minor motor vehicle offenses. Sit and wait, leave one of the Leominster police officers there. Yep, if he's there, he's going to come out. But to invade the privacy of Maura Stanley's home at 9:40 in the morning, she was at the door wearing only a comforter. You know, this was a household that wasn't up and out the door. They were still, you know, in their bedrooms, the testimony was. You need a little more. You need a little more than that.
Could he have, well, probably not. Could he have taken that into account? In other words, she's still in, as you say, draped in a comforter. It's 9:40 in the morning. He hears some noises. Somebody else might be in bed.
Yeah, maybe one of our kids. I mean, there's no record evidence that he, and that's another thing that was not developed, and he said, quite frankly, he had no idea when he went there whether Mr. Gentile would be there. He also had no idea who else would be there. So just hearing somebody, yeah, maybe she sleeps in, she doesn't have a job, but he has a job. I mean, there could be any number of permutations of what was going on in there, and he had no knowledge other than Mr. Gentile gave him an ID card that had that address, and that Mr. Gentile told him that he was staying there. And other than that, and other than her saying he's not here, and his determination that she was lying, that's all there was. And so I think what's important for this case then is the question of the consent that he gives back at the barracks and whether the taint from that unlawful entry was sufficiently attenuated to permit that consent be considered and to permit the troopers and the officers to go back into the apartment and get the sword and the BB gun, which Mr. Gentile told them, oh yeah, I saw those. I saw those. Well, I didn't see I don't think he said he saw the BB gun. He said, I saw the sword. And I saw it. Maybe he did say he saw the BB gun. The trooper himself saw it on the initial entry. You know, I think this court said that the issue of attenuation, dissipation of the taint, is trying to mark the place where, you know, punishment for unlawful police conduct, the reason for that has dissipated so much that excluding something that comes after is no longer necessary to deter that misconduct. And what you have here, you know, in Brown v. Illinois, you've got passage of time, intervening circumstances, or the flagrancy of the police misconduct are the things, the factors you look at. What you have here is the trooper testified that he entered at about 9:40 in the morning. He arrested Mr. Gentile within 5 minutes. They took him down to the barracks. The consent form was signed at 1:45. 4 hours. That is not long, especially considering the person who signed the consent is the person who was the target of the investigation. He was the reason for the unlawful entry, and the consent was obtained from him after he had been in police custody the entire time, the 4 hours. There were no intervening events that would have sufficed to cut the taint from that event. And so I would suggest that it was raised as a fruits of the poisonous tree issue below, and the judge simply didn't reach it because he determined that the entry was lawful. So he did not go on to decide the fruits of the poisonous tree argument.
Do you also, maybe I'm wrong, do you also have an independent argument that it wasn't voluntarily given? I mean, quite apart from whether the entry was or wasn't lawful, but just in this, I thought you were arguing that as well, but maybe I missed that, right?
I did argue that. I think that the question, anytime that there is a consent, the question is whether the consent was coerced, or, I mean, a consent can be given freely and voluntarily, but it can't be just the acquiescence to the power of officials. And I think that just sort of falls into the same spot with attenuation, the kind of factors you look at. He's been in custody for 4 hours. You know, he's under arrest. He knows they're investigating him. The trooper says, we were investigating him for these items, and they're questioning
at this point,
him.
so he's under arrest for the warrants on the motor
Right.
vehicle violations. They're investigating because when they arrested him in the bedroom, they saw things that they believed were taken in a theft from another house, right? So they
Well,
were investigating that?
Well,
There's something like that. I mean, he says something that might give them thought of that,
Well, I
right?
think the way, if you look at both the motion to suppress transcript and the trial transcript, the testimony came out a little differently at trial, but in the motion to suppress, but I think the trooper says both times that when they go into the room and they find him behind the door, and they tell him they're arresting him on the warrants, and they say, you're going to have to get dressed, and he picks up a pair of shorts next to the bed, and the trooper walks him toward the closet area to grab a T-shirt. And at that point, the trooper sees the butt end of a rifle under the bed. He doesn't say anything. He brings Mr. Gentile back to the side of the bed, and he says, are there any weapons? Are there any weapons, or are there any guns in here? I think he said guns. And Mr. Gentile said, no, there's no guns in here, but there's a knife on the dresser. Apparently he had a knife. And so the trooper then pulls them out, finds the gun cases, finds the two
Pulls what out?
shotguns.
Pulls
the antique
gun out from under the bed.
under the bed, and then pulls out and sees the cases and pulls those out. Mr. Gentile says, I know whose those are, but I'm not going to say anything. They're not mine. At the motion to suppress hearing, the trooper testified that he had no idea those were stolen until they got back to the barracks and he ran the serial numbers. And at that point, they realized that all the items were taken from a break in Sterling on June 24th, June 18th or 15th, 2010. And at that point, they ask him, they've got a Sterling police officer comes and brings the list, and he says, oh yeah, they ask about the sword, which the trooper had seen. He said, yep, I saw that in there, and a BB gun. The consent was for those 2 items, and those are the 2 items for which he was convicted, yes.
And they were both in the bedroom, those items?
They were both in the bedroom. I believe the sword was behind the door, and the BB gun was next to the closet.
Okay.
I
Thank
see
you,
that I'm
Counsel.
out of time. Thank you, Your Honors.
Good morning. May it please the court. Jane Sullivan for the Commonwealth. As this court has pointed out, there was not just nervousness that the officer confronted when he knocked on the door to serve the arrest warrants. He actually heard movement coming from inside Miss Stanley. She was looking nervous, not just looking nervous, but she was looking back to a bedroom that was directly across from the doorway.
Could you just help me remember what the facts here are about the other occupants other than the defendant? The other 2 women in addition, I mean, his wife answers the door.
Right, or wife or girlfriend answers the door. There's her daughter, 14 or 15 years old, that Trooper Napolitano says is standing close to Ms. Stanley
So she
near
comes
the
to,
door.
basically comes to the door
Yeah,
roughly, too.
the trooper actually sees
So
her
he
there.
can see, so he can see her.
yes,
And what about the third female?
And then there's the third female. She comes out at some point later. The trooper did not see that third female.
After or before he hears the noise?
I believe that's after he hears the noise.
So.
I believe that's the
So
testimony.
the noise could be explained by her?
Well, it possibly could, but the information available to the officer at the time, the only person they knew resided in the apartment was the defendant.
Right, but what I'm saying is, I'm just trying to assess the noise factor here.
Okay.
How much can that factor in once he hears the noise and then he hears or sees somebody come out and it's not the defendant, it's.
But he doesn't see.
It does not explain
He
the
doesn't
noise.
know that until after he's in the bedroom and he finds the defendant naked.
No, I mean, he doesn't know, I'm just saying.
The woman doesn't come, as far as the testimony is, that woman doesn't come into the picture until
after he's
after
entered.
the
Oh,
officer
okay,
is in the
okay,
bedroom.
okay,
And after he finds the defendant naked hiding behind the
Okay,
door
so
in that
the
bedroom.
noise remains a factor because he doesn't know about this third woman yet.
The noise is a huge factor because at the time, the officer, defendant confirmed that's his apartment. They have no information that anyone else lives in that apartment. And so they may have been surprised to see this woman open the door. But her movement towards the back, even though she's saying he's not here, the officers were not required to believe that. And I would just direct the court to the Lefebvre quote that's in my brief at page 19. It says, noting the reasonableness of an inference that a defendant would be at home in the absence of facts tending to show that the defendant is not at home, and recognizing that an assertion by a friend or relative that a defendant is not at home may well be an attempt to divert the search and facilitate escape or concealment.
Could you explain to me, did the officer explain what he meant by noise? I mean, radios make noise, TVs
No,
make
he did.
noise.
He thought he heard that there was some sort of movement, like something banging against something. I don't know if he actually used banging, but there was some sort of movement, and he thought it was coming from the bedroom that was directly across from the doorway in which he was standing.
But did he
Well,
also
a pet
say he
could
thought?
make noise too, right?
Excuse me?
A pet, a dog, a cat.
Yes, again, but there was no information available to the officer that there was a dog or cat in there. There was information available, but that the defendant lived there.
But did the officer say he thought that it was a sound of human activity? That it was?
I believe, yes, I
that
believe
there was
he did.
another person there.
I believe he did, and I'm not sure if the.
Says that you could tell there was somebody else there. I didn't know
Somebody-
who
right.
was there. I saw the one girl, and I couldn't tell if that was the only other person there. I couldn't really also understand from this particular cite to the reference that he meant he had seen her or if he was looking at her. It's, to me, rather ambiguous that she's still
believe-
there, or whether he's saying, I knew there was another girl. I didn't know if that noise was her or someone else.
I believe it's later on cross-examination, I believe, where it's brought out that, no, the girl was standing somewhere next to, it seems to me it was clear that the trooper saw the young girl next to Ms. Stanley at the time he was on the threshold.
Didn't the 14-year-old girl actually open the door?
There was testimony, not from Trooper Napolitano, but I believe the officer who was backing him up, that that the young girl actually opened the door, and then Miss Stanley came to the door. But the testimony was consistent, and the testimony that the motion judge credited was the testimony of Trooper Napolitano, and that was that he spoke with the woman, Miss Stanley, who came to the door in the comforter, and that her daughter, the girl, 14 or 15, was standing sort of next to her as he
What
was talking to her.
information, you've said a couple times, the police had no information that he lived with anyone. I mean, what kind of information did they have about the defendant at all? I mean, is it the assumption that, well, okay, he lives there, so then the assumption is he lives there alone? Or did they have information that he lived there alone?
The police have to go on what information that they actually have. They could lawfully go to his residence, that he declared as his residence, that they confirmed before they went in there through Registry of Motor Vehicle Records that was his residence.
So they know that he lives there.
And so they could go to the,
Right, but they don't know anything. It's not like they had no information, it's not like they had the presumption he lives there alone. They just didn't know, one way or the other, whether he lived there alone.
Right, but I don't think that, I don't know that that's necessarily important. It's just important that they didn't have any information that anyone else was living
Not a
there
surprise,
in order
though,
to
if
assess
somebody-
the situation that they're faced with when they get there. I think that's just simply my point.
It would be reason, if you're hearing noise, it would be reasonable to expect, since they've been told he lives there, that other person may well be he.
Would be the defendant, right? I think that's an entirely reasonable inference to be drawn, and based on those specific observations, the officer was justified in entering the apartment and going directly to the bedroom where they found the defendant. And during the course of escorting the defendant back to his closet where he retrieved a shirt, they noticed the butt end of a rifle sticking out. And based upon that, the officers were warranted in seizing those rifles, arresting the defendant, bringing him to the barracks. And that's where, after being Mirandized, he told the officers that he knew that there had been a theft, he knew that these had been taken in the theft, and he identified the sword and the BB gun, and then he gave a fairly comprehensive written consent to, and he accompanied the officers back to his apartment, which he identified as his apartment, and he said that he had, he could give consent to search the apartment, and he directed them to where they would find those items, and the officers went to the apartment and retrieved those items. So I would suggest that the officers acted entirely lawfully in the situation, and as a result, that the evidence, the defendant was acquitted of the firearms charges, but the evidence as far as the BB gun and the sword was properly admitted into evidence.
Do we have any case law as to the meaning of reasonable belief? Is it the same as reasonable suspicion? Is it different?
I believe the case law is it's similar. I mean, I think you have to articulate facts, so it would be similar to reasonable suspicion, but it may not. It certainly isn't probable cause, and I don't know that it technically rises. But there has to be some sort of facts that you can articulate, like there are here, that would justify the belief that the person is at home.
So you're not, I mean, it seemed to me from a quick reading, and that's all it was, of the judge's decision, he laid a lot on, I forget the term he used, but the ability of the officer to discern sincerity or lack of same. But you don't disagree that you really need.
No, I agree that there needs to be some sort of
that will not
some
do
sort
it.
of facts that would lend that, but I think you have to look at the facts confronting the officer in light of the officer's experience and, frankly, in light of common sense. And I think that Lefebvre quote that, it's reasonable to expect that friends or relatives who might answer the door of the apartment might say he's not here, or when in fact they are there. So I think all of that does come into play. But I believe, no, just the fact that it's the defendant's house and I didn't believe her when she said no. No. I don't think that would pass the test for entry into the apartment. But here, we have way more than that here, and I would suggest that the police officers acted with restraint, actually, and acted appropriately and properly seized the evidence.
Was he arrested just on the warrants, or was he arrested for the theft?
He was arrested initially just on the warrants because they didn't know the guns had been stolen. The officers knew
so
from.
when he was in the police station, he was just there as a result of the warrants.
Right, he was being processed as a result of the warrants, and then they ran the serial numbers on the guns, and then it opened up, it opened up after that, and they called the Lancaster Police.
So it's your position that if there was any taint from any illegality, it was attenuated?
I would say it was certainly attenuated, both by time and space. The arrest happens around 9:40, whatever, and the consent, and if you look at the consent form, it's a very comprehensive consent, yes, I would suggest that it was attenuated, and it was broken by the arrival of an independent police department, the Lancaster Police about, or Sterling Police. Sterling Police, excuse me, about the theft. So I would suggest that, yes, so at least, even if there was some sort of impropriety, that there was. That was not litigated below. And I had submitted in my brief that it really wasn't raised in the defendant's motion. I don't believe it was, but I do have to agree with my sister's point in her reply brief that it does seem like, look, as though the case was presented to the motion judge on the theory that, this case rises and falls on the legality of the entry. So it really wasn't pushed by the prosecutor. So although I think the facts were there, I don't know that it was preserved for us. And unless there are any further questions on any of the other issues, I'd be willing to rest on my brief.
Thank you.
All right, thank you.
Thank you.